The special meeting of the Board of the Manatee County School District will come to order. If you'll please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And for those that are not seeing what we're doing, will the Secretary, Dr. Green, please call the roll?
Mr. Cologne?
Present.
Mr. Kennedy?
Hello.
Dr. Hopes?
Here.
Ms. Messenger?
Hello.
Thank you. And Mr. Teitelbaum, are you prepared to present your case?
Yes, I am, Mr. Chair. May I proceed?
Yes, sir.
Members of the board, Madam Superintendent, Council, good afternoon. I'm here on an administrative complaint pertaining to Jerome Heaven for his termination. And on behalf of the Superintendent of Schools, Dr. Diana Green, she recommends the termination of Jerome Heaven. And let me tell you what the facts in this case are going to show as an opening statement. Mr. Heaven has been employed by the School District of Manatee County since February of 2003. And he was arrested on July 27, 2017 by the Bradenton Police Department for solicitation of prostitution. And he was thereafter criminally charged with solicitation of prostitution in violation of Florida Statute 796.07, and of significance, that is a first-degree misdemeanor. The evidence is going to show that the district was alerted of this arrest through the Florida Department of Law Enforcement. They conduct continuous criminal background checks. Those background checks are continuous for all level 2 screened employees. Upon an arrest of an employee of the school board, the FDLE generates a printout to the school district, and we are thereafter properly notified. Mr. Heaven's position was a bus operator, which required him to work in direct contact with students. And upon learning of his arrest, he was immediately placed into a temporary assignment where he did not have any contact whatsoever with any of the students. This allowed the due process for Mr. Heaven as his court case progressed. On February 8, 2018, Mr. Heaven appeared in the Manatee County Circuit Court for a jury trial regarding his charges. And he was represented by an attorney, and his case was tried before a jury of his peers. And he was found guilty for the offense of solicitation of prostitution as charged. As mentioned, solicitation of prostitution is a violation of Florida Statute 796.07. It's a first-degree misdemeanor and is a crime involving moral turpitude. As a result of that criminal conviction, Mr. Heaven is no longer qualified to work in the capacity that has direct contact with students and children. And he's no longer able to fulfill the requirements of his position as a bus driver. That's a position that has been approved by you good board members. And our school board policy does address this situation under 4121.01. And that incorporates Florida Statute 1012.32, which prohibits employment for individuals convicted of crimes involving moral turpitude. And by reference, our policy references the definition of moral turpitude as defined by the State Board of Education, Rule 6A-10.083. That, and I want to make it very clear, applies to instructional personnel and administrators. However, we as a school board incorporated that definition to our own policy. So let me tell you what 4121 says. A person who is found through background screening to have been convicted of any crime involving moral turpitude as defined by the rule of the State Board of Education, or otherwise found ineligible for employment under a different statute that applies to educators, shall not be employed in any position that requires direct contact with students. That's our school board policy. And Florida Section 101232, where it's modeled after, said to be eligible for employment at the school board, you have to have good moral character. And then at the bottom of that section, or otherwise found through background screening to have been convicted of any crime involving moral turpitude as defined by State Rule Board of Education, shall not be employed, engaged to provide services, or serve in any position that requires direct contact with students. Now, Rule 6A, which we incorporated into our policy, again, that involves educators, but so does the professional rules of conduct that involves only educators. We incorporated them into the School Board of Manatee County policy through our Neola. And that states specifically what moral turpitude, and this is very important, shall be defined as a crime regardless of whether the individual is charged or convicted that is a felony or a first-degree misdemeanor. And it goes on to state, as evidenced by an act of baseness, vileness, depravity in the private and social duties, which according to accepted standards of time, a man owes to his fellow man or to society in general, and that the doing of the act itself and not its prohibition by statute fixes the moral turpitude. Members of this board, the conviction of Jerome Heaven for the offense of solicitation of prostitution is a violation of Florida Penal Code Section 796.072F, a first-degree misdemeanor and a crime involving moral turpitude. That's what the evidence is going to show. And Mr. Heaven has been effectively compromised in his position and role as a bus driver, and he can no longer be placed around students. And the criminal conviction for the solicitation of prostitution impairs his effectiveness in the school district and under the principles of professional conduct for education profession in Florida as we adopted in our other policies. And whether he's on the clock or off the clock, he's still a school board employee and he's to be held accountable. And based upon the foregoing, the evidence is going to show and the recommendation from the superintendent is the termination of Jerome Heaven. Members of the board, thank you for giving me the opportunity for my opening statement. Want me to, Joe?
Mr. Chair, I think that was the administration's opening statement. It's common to ask Mr. Heaven if he would like to do that now or wait until he presents his case in chief.
Mr. Heaven, would you like to make an opening statement?
Yes, I would. Yes.
Will you please come to the podium?
Good afternoon, Dr. Green, and to all you chair people, and to everybody else too. My open statement today is that I'm going to give you a few reasons why I think you ought to rethink about terminating me. My opening statement, I'm going to give you a few reasons why I think you ought to rethink that. And I don't know whether the deputy showed up or not, but was asked to come the night of that event. Why I'm here and why we having this here? She was asked to come, and I guess maybe she didn't want to come or whatever. But what was stated about me in the paper is not true. And it's not according to the case that happened. And that's my open statement that we're going to talk about that just a little bit. All right. Thank you.
Thank you, Mr. Heaven.
Well,
Mr. Titlebaum.
May I proceed?
Yes, sir.
Thank you, Mr. Chair. Okay. In front of each of these board members and for the agency clerk, I have exhibits to be entered into evidence.
Excuse me, Mr. Titlebaum, for a moment. Mr. Heaven, would you like to come up front to the table during the presentation of the case, or would you prefer to sit in the back of the room?
I'm okay. I can hear.
Okay.
Okay.
All right.
And I'm going to let you know, as per the last board meeting, these were exchanged with Mr. Heaven. Okay. The School Board of Manatee County School District moves for the admission into evidence the administrative complaint with affidavit of service. That's Exhibit A.
So admitted.
Moves for admission into evidence Exhibit B, the request for a hearing that was filed by Mr. Heaven.
Show Exhibit B admitted.
Requests respectfully the admission of the notice of hearing with affidavit of service, which is Exhibit C.
Show Exhibit C admitted into evidence.
Moves into evidence the police report as Exhibit D.
Show Exhibit D
Police report. Admitted to be admitted.
admitted into evidence.
Thank you. And Exhibit E, the School Board District of Manatee County moves for into evidence the certified order of conviction, which is the which is a certified copy, the record of conviction. It's stamped on the back. It was obtained by the court system as case in chief.
Show Exhibit E admitted.
The school district, School Board of Manatee County moves into evidence the policy and procedure manual section only, 4121.01.
Show Exhibit F admitted.
And as Exhibit G, the school district, School Board of Manatee County moves into evidence Florida Statute Section 1012.32.
Show Exhibit G admitted.
And the school district of Manatee County also moves Exhibit H into evidence, which is the Florida Administrative Code Section 6A-10.083, with the proviso that this does provide a definition that is for instructional personnel, but we incorporate it by reference into our definition, our policy.
Okay, show Exhibit H admitted.
And also moves into evidence Exhibit I, Florida Statute Section 796.07, which is solicitation of prostitution, evidencing a first-degree misdemeanor.
Okay, show Exhibit I admitted into evidence.
Members of the board, based upon these, may I proceed?
Yes, sir.
Okay. Members of the board, based upon the admission of these evidence, the case is very simple. As stated in my opening statement, through the administrative complaint, it lays out the case in chief, gives a due process to Mr. Heaven. The request for hearing, which is Exhibit B, was his direct hearing request today, which we've given to him by our obligation from the district. Once you do request a direct hearing, it can be held through DOA or a direct hearing request. I made a request prior to the previous board meeting asking for your direct hearing. Ultimately, it comes to you guys anyways. So,
Correct.
And that was granted by you, Mr. Chair. The police report gives us the nature and surrounding of the circumstances of which Mr. Heaven was arrested. Exhibit E is the case in chief. That's a certified record of conviction. That tells you from the court system that he had his jury trial. And that's an order of probation as well. It tells you he had his jury trial on a date certain. He was found guilty of solicitation of prostitution. Exhibit F is our policy and procedure manual, which states that we cannot keep him employed in a position that was with direct contact with students. And Exhibit G, which is 101232, reinforces our own policy. That's where Neola got it from. Exhibit H defines moral turpitude and also tells you it's a first-degree misdemeanor. Case in chief is that solicitation of prostitution is a first-degree misdemeanor. And Exhibit H demonstrates that as well. And Exhibit I is in fact a statute that will confirm that Mr. Heaven has been convicted of the crime of solicitation of prostitution, a first-degree misdemeanor as well. That is the case in chief on behalf of this administration. And I welcome any questions.
Members for questions?
Yeah.
Mr. Cologne.
Mr. Titlebaum, has Mr. Haven seen a copy of these documents?
Yes, they have. And
Because
Mr.
I don't see them with him, so I'm asking if he knows everything that's in here, agrees with it, understands it.
Mr. Heaven was given a copy of these exhibits at the last hearing. I actually I have an extra copy if he wants another.
Do you need another copy to peruse?
Okay.
Fine.
And in addition to that, as per your directive, Mr. Colon, I just want to state something for the record. During our last board meeting, there was an issue of whether or not this attorney who works for the superintendent of schools and this board had an obligation to prepare subpoenas and service a process. And I asked for clarification before the board. And I met with Mr. Heaven thereafter. I sent a certified letter, as well as regular mail to Mr. Heaven and informed him exactly what you told me to say. In regards to, it's up to him that the administrative hearing would take place on April 10th at 2 p.m. And if he needed to subpoena anyone to compel them to appear at the hearing, it's his obligation to, one, prepare a subpoena, present the subpoenas to the agency clerk for signature, and have said subpoena served by an individual of at least 18 years of age and not a party. I did exactly what you told me to do, Mr. Cologne.
All right, thank you.
Thank
I
you.
appreciate it. I just want to make sure he's given every opportunity to defend himself. He understands the charges against him, and he understands the documents, or if they need to be further explained to him, that we make that available. That's
Absolutely.
all.
And Mr. Cologne, just for a point of order for me to tell you, he was convicted by a jury of his peers, but the statute doesn't even require the conviction. It requires him to be charged with it for us to take action. But he's one step above being charged. He's actually convicted of a crime involving moral turpitude, a first-degree misdemeanor.
Mr. Kennedy.
There we go. Thank you, Mr. Chair. Mr. Titlebaum, I just have a couple small detail questions. The arrest took place on July 27th, 2017. And then in your, I guess I'm not sure the correct legal word, pleading before us, or what you submitted to us, it says the district was alerted to the arrest through an FDLA criminal background check. Do you know exactly what the time frame was
Yes.
between?
I have it on top of my head.
Go ahead.
I was alerted, if I'm correct, around August 1st or August 2nd. That was the first opportunity for us to be alerted. And once we were alerted, the standard protocol, as per the superintendent of schools,
Excuse me, you didn't say August, did you?
July 20th.
You meant,
Yeah.
this occurred according to, oh, I'm sorry,
Okay.
it's court date and time.
Yeah, no, we immediately, once we got notified, the first thing I'm directed to do is to alert our superintendent of schools. Madam Superintendent, we have an arrest. It's involving an employee in a particular department. These are the allegations. Madam Superintendent, can you please give me further direction of what to do? That particular instance was immediate reassignment of the standard protocol to remove that employee with any contact with students, to safeguard our students from any contact, to allow due process to take place. And that's exactly what we did in this particular instance.
Okay.
So we didn't prejudge the case. This case languished. There was delay after delay for this trial date. We waited for it. As soon as the trial date was over, he was afforded due process, and we proceeded, Mr. Kennedy, as quickly as possible to afford the employee the opportunity to have his day before this particular board.
Okay.
And he wanted an evidentiary hearing. If not, it would have been done in default.
Okay. Mr. Chair, if I may. Thank you.
Continue.
Really, the nature of my question is about when an employee when an employee is arrested, and
Yes.
the policy around that happening, and you referenced this earlier. If I'm correct, if an employee is arrested, they must self-report to their supervisor?
This is a very interesting question. Under our policy, it involves two particular crimes: drugs and something of a sexual. I'm gonna say drugs and child abuse. I was gonna say sexual, but not all sexual. Child abuse and drugs, and this did not fall in that category. So
Okay.
once we were alerted by the FDLE, there was no violation, nor is there any allegation that Mr. Heaven did not fail to do anything else or fail to cooperate. At all times, he's been respectful of this process.
Okay, thank you. Thank you, Mr. Chair.
Any other questions, members of Mr. Tannenbaum? Are we ready for Mr. Heaven to present his defense?
Yes.
Mr. Heaven?
The school board, school district rests subject to rebuttal.
Thank you, Mr. Tannenbaum.
Thank you.
Mr. Heaven?
Where do I start here? Well, I guess I'll start with the reason of, I said I would give you a reason, to reconsider you terminating me. Every year that, I've been driving bus for quite a few years, and every year we have this meeting, this conference meeting with the superintendent come in I think Dr. Green maybe 1 year or something, but all the other superintendents too come in. You know what they tell us? They tell us, you are the first one that these students see to get on the bus and the last one that they see going home and all that. And you tell us about how good we are and all we do to get the kids to school and all that. I don't think you all really have a clue, to tell you the truth, about really what happened on the buses. That's what you all tell us, and you don't pay us enough, for one thing. And then let me give you just an example of a driving school bus. It's far more than driving school bus. That the buses are, many of them are loaded with kids from 50 to 80 students. Actually, sometime 84. I had a bus that had to call in another bus, an 84 passenger bus, had to call in.
Mr. Titlebaum.
I'm going to object to this. This is not a defense, but we're here for the defense of the criminal charges, not for a diatribe in terms of our transportation department.
And I will sustain your objection. Mr. Hebner, you had an opportunity for your opening remarks, which gives you great
That's right.
latitude. Now is your opportunity to provide your defense
I am, but
specifically against the allegations with which your employment is being requested to be terminated.
That's what I'm doing. If you let me do it, you guys want to say what you want to say, but you don't want me to say what I want to say. And you told me the last time I was here that you was going to give me at least an hour in this. And last time I was here, you all took up the time that I didn't have to speak, nor the people I had here to speak for me. Now you telling me how to tell you what's going on. I'm sure you saw the tape. There's a tape of the event of July 27th. Did you see it? I'm talking to the chairperson, Hopes.
We are basing our decision based on the evidence that's provided to us.
That is
by the council.
evidence. Did you see the tape? Is what I'm asking you, because that is part of the case. Or I'm here to defend myself. You want to fire me
for your defense. Do you have the tape that you want us to view?
I'd ask you, did you see it?
No,
there is a tape
you've-
on it. He saw it.
You've seen the evidence that's been presented to us during this case. We're obligated to not go out and do our own research. We're obligated to receive.
This is your attorney. He did it. He went out and he told me he saw the tape. He told me he saw it.
And he may have. What I'm
Well,
suggesting.
let me say this to you.
Okay.
Let me finish saying, whatever your decision that you all have already made or something, at least give me my time to say what I like to say.
Okay. Please continue.
Thank you. I appreciate that.
But if you would, based on the objection of counsel, would you limit
I
your
object.
test?
I object to what he's saying, because he had his say. Give me my say. Because you all already determined. He said that you already determined to fire me.
No, I don't.
Well,
no.
let me give you.
Mr. Haven, nobody has predetermined to fire you as yet.
Show.
Otherwise, I would not be sitting
Wait,
here
Mr. Cologne,
spending my time
Mr. Cologne,
doing this.
Hold on just a second. So there's been a motion to strike Mr. Heaven's last comment, if you'll show that stricken from the record.
Mr. Chair?
Yes, sir.
We can't strike
Oh,
anything.
okay.
Yeah,
Okay.
it's
I was just
it's
reacting
all in
to-
the record, yeah.
Okay.
Listen, let me finish. Let me give
sorry,
you
this
an
is-
example. Let
okay.
me give you
Please
an
continue.
example
Please.
about bus driving. Now, you guys hire us to do this bus driving thing, and then here's what seemed to be the most important thing right here today about you all and me, is that your attorney is saying about talking about around children, don't want me around children. Man, listen, I got 13 children of my own. I'm the father of 13 children, and I have 37 grandchildren. I'm around children all the time. Are they around me? I got kids still in school, grandchildren in school. And you talking about don't be around kids? That's crazy, to tell you the truth. It's really crazy. And not only that, listen, I said that I was going to give you an example about why I think you ought to change your mind about talking about firing me. Listen, driving school bus. I remember on one instance, these kids on the bus are not mine, but they are mine too. That on one instant, one morning, a man come up to the bus and he says, where's my daughter's phone? He stepped on the first step of the bus. I said, hey, hold up, man, hold up. You can't come on this bus. You know, mine now, these are not my kids or my grands. There may be some of yours. But he comes up, I said, you can't come on this bus, bro. Now you could take your daughter with you if you want. Or you can call 708-8800 transportation and find out, but you can't come on this bus. And I'm looking after your kids. And not one time in all the years I've been working for the school board, not one time have I had reprimand. And before that other case that you're talking about before, I actually won that case with you guys.
Just for a point of order,
Mr. Tannenbaum.
Mr. Heaven's past disciplinary action in this district was never introduced by this attorney, and I ask this board respectfully not to consider this, because he's here to be determined whether to be terminated on the merits of this case. Nothing that ever took place in the past. Only this case has been presented. Therefore, any procedural history has been completely omitted in this particular instance for those very reasons of not to prejudice Mr. Heaven.
Okay, it's noted.
I object to that. And the reason I object to it is because he is one that told the people talking about all this garbage in the paper about me that is not true. It's not true, it's not accurate, and it's not true. And it also mentioned the case that he's telling you about not listening to. It also mentioned that.
Part of the board rules, your attorney works with the superintendent of schools. I'm presenting my case.
Right.
First, I believe the adage is, first we try to attack the facts, we can't attack the facts of the case, we try to attack the law. And now I'm seeing the adage that this lawyer is being attacked, and I'm objecting to it. We don't slander staff in here. If he wants, I've taken the high road.
It's facts. Read the
Okay.
paper.
Miss-
Everybody
Miss-
else have read it.
Mr. Heaven, are you admitting your employment record into evidence for our consideration?
No, I'm saying that what the paper said, the paper mentioned about it.
Okay.
And he's saying that it's only this case. You guys bring up all that stuff, and I won the case with you guys. I won against you guys. And then now he's saying that you don't want to bring that up, but yet the paper brought it up about me and lied about me. It is not true what the paper said.
I think the district's attorney is suggesting that for you to defend your case, which is before us, to go through the evidence that he has provided and either rebut it or give us your argument for why this body should not find Mr. Teitelbaum's presentation accurate and correct with regards to your conviction.
Okay? Let me give you one even better than that. Is that the last time I was here, man, look here, I was scheduled to have a hearing at 9:30. You guys didn't get to me till about 12:45. Not only that, but now you guys sit in those chairs up there and you want to fire me after all the years that I done put in here, never had a reprimand of any kind that I was wrong about. Never. And you want to fire me on something, let me tell you, the things that I don't think is not one of y'all up there that they haven't been through something. And the stuff that I heard last time I was here in this meeting with you, and you talking about firing me, man, I think they ought to move y'all chairs out from up there. If you talking about firing me on what happened to me, and let me give you another one about that. I wasn't even, you guys were not even paying me during that time. I wasn't even working for you during the time that happened. That I was entrapped. That's exactly what it was, entrapment, totally. I wasn't even working for you all. You all did not even give me a pay. I was not even working. And every year we come back, we have to renew our contract with you guys. And you guys talking about firing me on something like that? I think your chair ought to be moved. Cause I think you're being inconsiderate when I take care of not only your children or other people's children, but all the ones that ride my bus. Not one that ever rode my bus could say that I mistreated them or done wrong toward them. Yet you want to fire me for something I wasn't even at your job. You weren't even paying me. And you want to fire me for something like that? Man, your chair ought to be moved. But now that's just me. You keep your chair if you want. But I think your chair ought to be moved if you fire me. You know? And the other thing is that the cop that refused to come, this paper here, let me just read you something that the paper said. Paper said, on July 27th, during an undercover operation for the police department, Bradenton Police Department, targeting John soliciting prostitution. According to the arrest report, the undercover detective was in the 2500 block of 14th Street West, Bradenton, when Heaven, talking about me, told her he was looking for sex. How many people get the paper and read this garbage? I told her I was looking for sex. Man, it look like, I mean, I don't know about you, but do it look like, I have a problem getting a woman? Let me tell you, no, never did. And then you talk about to ask her for sex. All this junk been written in the paper about me, which is not true. And then just a little bit more. Just a little, I'm going to be done. Police report said that Mr. Heaven told her he was looking for sex, police reported. The two agreed to have sex for $35, and once he paid her, officers moved in to arrest him. Man, come on. If the lady had showed up and come, she was requested to come. Now, for whatever reason, they told me she didn't have to come. But I guess that's just the system. But it's all a lie. She never got any money from me and never was going to get any money from me. So it was really solicitation. And then the case that you guys present here today with your attorney, I'm not worried about talking about the solicitation stuff and all that. That's garbage to me. But what is important to me is that you talking about all this junk about not being around children. Again, I have 37 grandchildren and counting. And children around me all the time. Children even from your schools come up to me and ask about advice and different stuff. They come through my neighborhood. I live close to one of your schools. And they come up with their pants down. When they get near my house, know what they say? Hey, man, pull your pants up, man. And you want to fire me. I think you ought to find the biggest mirror first and then just look in it and then just say whatever you got to say to it about me. But to fire me on something like that, I think that you guys really need to have some kind of program or something set up, or something set up where you reprimand a person first, and rather than talking about you want to fire me on something, you guys weren't even paying me. I wasn't even on your clock. But I guess your mind made up that, hey, listen, we're going to let the attorney handle that, and we're going to just go ahead and go along with what he says. It's a lie. And all this garbage that people done read, put in the paper about me, not true. Did I get, did the cops take me to jail? Yes, they did. But they entrapped me to take me to jail. I guess I just wasn't wise enough that night not to fall into their trap. But which one of you, start from the chair that's empty, right on round to the other empty chair, which one of you have never been entrapped? Which one of you have never did anything? I mean, you know, you look at the thing that what you all got me here for today, or what I call this hearing for today. Just consider what it is that I'm here for. The allegations of it. Which one of you have not had something just as bad, or if not worse? I can stand here and tell you, I know that you had one just as bad, if not worse. Yeah. So, you know, and you still want to fire me. Wow. You guys tell the bus drivers talking about you important and all that. And you want to fire me on something like this. Hey. I think that's all I'm going to say, I think, right now. But I think I'll say like the lawyer said, with a rebuttal. Thank you.
Mr. Titlebaum, please approach.
Okay. For a rebuttal, I bring back to the board's attention that on February 8th, 2018, for the defense presented of entrapment, then on February 2018, Mr. Heaven appeared in the Manatee County Circuit Court for a jury trial regarding his charges. He was represented by counsel. In his case, he was tried before a jury of his peers, and he was found guilty for the offense of solicitation of prostitution as charged, first-degree misdemeanor. Thank you.
Thank you. Members, any further questions or debate? Mr. Kennedy.
I have rebuttal. I'd like to say something else.
Okay, please approach, Mr. Heaven.
Mr. Chair?
Yes.
It's customary for any further rebuttal to be limited to the remarks that Mr. Titlebaum just made, not to get back into it again.
So Mr. Titlebaum's comment was regarding your conviction. So limit your rebuttal to Mr. Titlebaum's restatement of your conviction in a Manatee County court by a jury.
Okay. That conviction, what they did, I feel like they were wrong because there was a reasonable doubt. But anyway, that it had nothing, this whole thing had nothing to do with any children. Had nothing to do with any children. Thank you.
Thank you. Mr. Kennedy.
Mr. Heaven, if you could stay up here.
Mr. Heaven, for a question?
Mr. Heaven, I have a
From
couple
Mr.
questions.
Kennedy.
Yes, I'm sorry.
That's okay. That's all right. Mr. Heaven, I just want to ask you about your comment about your job status. And this obviously happened in the summer, late summer of last year. So as a bus driver, are you contending that you were either obviously at this time of the night, you're not working for the school district, but over that summer, are you performing job duties at the transportation department?
No.
So as a bus driver, when do you sign your contract and go back to work for the school district?
August, when we come back for conference.
So you're making the claim that you actually, at the time this happened, were not under contract with
That's
the district?
exactly right.
So your previous contract for the school year that ended in June of 2017, when does that work contract end?
Well, now, I'm not sure. You guys got the paper. You guys make the rules for that. But I'm telling you that I was not under contract with you all when that happened.
Okay.
Listen, I think that y'all up there, I think that you ought to reconsider your decision about me. I really think that you ought to.
Mr. Chair, I have a couple more too.
Mr. Kennedy?
Mitch, I just got a couple more questions. Let me get everything out to him and then maybe you deal with all of it. Did you have an attorney when you were convicted in local court? You had representation?
Public defenders, man,
Okay.
I thought it was cut and dry case. I should have had one.
Okay. Wait, you had an attorney, correct?
Public defender.
Okay, that's a lawyer, right? And then you mentioned that you have a large family, a lot of grandkids.
I mentioned I'm the father of 13 children and 37 grands.
Okay. And this is personal to me because this is my neighborhood, this is my district. You are a resident of the district that I represent. This part of 14th Street is 5 minutes away from my house. So this is, I'm taking this very seriously. Whatever you're referencing in the newspaper, I haven't even read any of that. I'm basing this on the facts of the case that are in this binder and nothing else. I can promise you that. But I do want to ask you a question just for kind of thinking about. If one of your grandchildren's teachers were in the same situation you were in, would you want your grandchild to be in that classroom?
Would I want my grandchild to be, as long as they're not touching my grandchild, because see, this is the fact about it. If you touch my grandchild or something, man, you're gonna have some trouble. So children, let children be children. Let children be children. Now that question that you asked, perhaps a loaded question or something. But like I say, I have a bunch of them, and I'm at their schools and I'm at their plays and whatever they're doing or something. But I say just don't touch them.
Okay, no, and I'm not trying to trip you up.
I think you are.
I'm really not, because I think you raise an interesting point with your employment status, but at the same time, I'm just asking yourself to
I think
put
it's
yourself
a
in.
loaded. I think it's a loaded question
Okay, that's
or
fair.
something, But my thought is okay. Your thought's okay.
Okay, thank you, Mr. Chair.
Okay, Mr. Kennedy. Mr. Titlebaum, would you like to?
Excuse me, I got one other question.
Mr.
We'll
Clone.
get it in. That conviction, that misdemeanor conviction, was there a fine attached to that?
Yes, it is.
How much, approximately?
Bunches. They want me to go to classes, public service, and all that kind of stuff. It's all. I mean, they read it.
I didn't read it.
You're asking me to.
I also didn't read it, so I don't know what's in the newspaper.
Yeah, it's a bunch of lies.
Whatever it is, I didn't read them, so
you know what?
I don't
Now
know.
you asked me the question.
Yeah.
I'm gonna be a little blunt about that, to tell you the truth. I think it's modern day slavery.
What's that?
The fines and all this stuff that they do, because it's no more the chains and the balls and stuff and working out but it's modern day slavery, because they want you to go to work, but they want to take your earnings, what you work for, that you can't live. So I don't know how do you define slavery, but I think it's modern day slavery in doing that, and especially on something like that.
Okay, Mr. Heaven. Thank you. Mr. Titlebaum? Did you have a follow-up, Mr. Kennedy?
No, I'm good.
Okay, just for
I
clarity,
think Mr. Kennedy's question related to the employment status
Okay.
at the time of the crime.
renewals, he's under a continuous contract. He cannot, Mr. Heaven is protected by his status. He cannot be terminated but for good cause, and his contract renews automatically, and you cannot terminate him. He's on a continuous contract based upon his particular status, and only good cause would be able to terminate him. The allegation to say that he's not a school board employee during that particular time period is irrelevant. He has guaranteed employment in this district, and he cannot be non-renewed, is the best way to say it. He has continuous employment status, absent a termination for good cause. And members of this board, in going directly to my conclusion and my summation, as we'd say in the lawyer's terms, good cause has been presented today. And there was an order of probation to one of the inquiries of, do you have to pay a fine? And Mr. Clone, can I answer that for you? Sure. Okay.
I'd like to hear the answer.
To begin with, he had to pay $55 towards supervision. He had to pay $249 in change in costs within 11 months. He had to pay investigative costs at the Bradenton Police Department for $100. He had to pay $50 costs for prosecution fee within 11 months. He had to pay $50 attorney fees within 11 months. He had to complete 100 hours of community service work within 11 months. And he also states, you will be screened for sexually transmitted diseases within 90 days. In addition, he will have to complete a restorative justice class within 5 months That is Exhibit E, the certified record of conviction. A prima facie case has been presented to this board that we cannot employ Mr. Heaven for a crime involving moral turpitude. Mr. Cologne?
So what you're also saying is basically that because of his continuous employment, he was technically still employed with the school board, he was only on vacation.
That is correct. He is a continuous employment. He has continuous employment until 1, he resigns, retires. That's 2, he retires. 3, or in this particular instance, there's something of misconduct itself or ineligibility for employment. We did not go into the misconduct path. This is the ineligibility for employment based upon Florida statute, based upon our school board policy. This is a first-degree misdemeanor, solicitation of prostitution. First degree, convicted. There's no dispute that he's been convicted whatsoever. And I'm asking this good board to make a determination that the superintendent's recommendation be upheld regarding the termination of Jerome Heaven. Thank you.
Thank you, members. Any other questions? Having heard the testimony by the district attorney on behalf of the superintendent and the defense provided by Mr. Heaven himself,
Are you going to give him any closing remarks or anything?
Mr. Heaven, would you like to make a closing statement?
Yes, I'll make one.
If you'll come to the podium, please.
I guess in my closing today, it's crazy to tell you the truth. It's kind of crazy that all the years that you put in on a job or something, and they can just fire you. I mean, just fire you just like that. And I realize that you all may, be thinking that, well, hey, listen, he got charged for solicitation of prostitution. But I really think that if there was a closer look at each of you, I really think that you would reconsider or find a different way of doing it. I mean, you wanna fire me. I mean, nothing had nothing to do with school board, nothing to do with kids, and you wanna take away my income, and so in my closing remarks, I think that you guys really don't pay us enough to do the job anyway, but yet somebody's got to do it. And we accept doing the job, and yet you guys want to fire me over this. I really think that you ought to take a closer look at yourselves. You do whatever you feel like you got to do or something, but I just don't see it where you would want to fire me, something like that, and nothing to do with kids. I know that this is a educational institution, and I went to school here. My children, my brothers, sisters went to school here and played ball and all that stuff. And I got grandkids playing ball, and sons too, playing ball even now. And it's something to think about. So, thank you.
Thank you, Mr. Heaven. Members, we've been presented with the superintendent's request and recommendation for the termination of employment of Jerome Heaven. We have conducted the hearing. We've heard from the defense. Is there a motion regarding the termination of employment of Jerome Heaven? Or does the superintendent make that request? Mr. Nye?
Mr. Chair, yes, you have to act on the superintendent's
Right.
recommendation. That's necessary first. I thought it was in the material, but I think if the superintendent wants to go ahead and make it on the record, there's nothing wrong with that.
Dr. Green?
Mr. Chair, excuse me. Mr. Chair, I am recommending to the school board that Mr. Jerome Heaven be terminated based on the case presented by our legal counsel.
So moved.
I second.
Have been moved and seconded. Any discussion, debate? Mr. Kennedy?
Sorry, thank you, Mr. Chair. I just have a quick comment. Mr. Heaven, I am going to support this motion and support your termination, really for two reasons. When you were here last Friday, there was a lot of conversation up here about holding ourselves as board members to a higher standard. And I think that's also true of all of us as school district employees. We need to hold ourselves to a higher standard. Second, this termination is not going to impact your long-term earning potential. You've been charged and found guilty of a misdemeanor. So I think and I hope that you will find a way to find other gainful employment. But it's just about, like I said, we in the school district need to be the example to this community.
But you're not.
Objection.
So you say. Thank you, Mr. Chair. Not always.
Any other comments, debate? Members, having been moved and seconded in favor of the motion to terminate Jerome Heaven, if you'll please vote.
They can't see it, so we need a voice vote.
Let's have a voice vote. We're not displaying it. All in favor?
Aye.
Aye. All opposed? Show the motion carrying 5-0.
Members of the board, thank you.
With that, the special hearing will adjourn.